Respondent counsel submitted his arguments. He said that they anticipated COVID and multiple COVID waves. But if you look at the very clause in the contract, it says material adverse effect are those circumstances which the parties would reasonably expect. So I think it is fair to state that none of us reasonably expected something such as COVID. And Your Lordship, what needs to be further read is that that very clause excludes governmental actions. So we have already submitted before you that the very lockdown itself was a governmental action. Therefore, they have not satisfied this court as to how that lockdown and subsequent cancellation stands within clause 2, subclause 2. The next rebuttal is that, Lordship, ultimately the contract was to acquire shares but not to conduct the fest. But the very argument of the respondents have been surmised on the basis that the fest was not conducted, which is a material adverse effect. Lordship, thirdly, we have not denied that the contract is determinable. In fact, I fairly conceded to this court as well. But what we are again reiterating is that they have not satisfied that the conditions to justify the termination is fulfilled in the instant case. Lordship, fourthly, and most importantly, there was a judgment of the US Supreme Court in the case of US versus Delaware. I know it's not binding on you, but it says that a short-term hiccup in earning does not constitute a material adverse effect. It should be something which is material and viewed from a long-term perspective. As I have already submitted, COVID was ultimately a temporary setback. It was not a permanent setback which paralyzed us of our ability to conduct future editions of the fest. So that should be viewed by the respondents. And finally, Your Lordship, they have also again not acknowledged and answered a question that we were ready and willing to perform the contract to the best of our ability and circumstances which were within our control. COVID was something unforeseen, unprecedented, and completely not within the control of anybody. Therefore, this is my humble submission. And it was again an honor arguing before this bench.
Thank you very much.
Firstly, I submit that the reliance on PUCL by the petitioners is slightly erroneous and misplaced. Because in PUCL, the substantive provisions of Section 5.2 were upheld. Yes, the court recognized that it lacked procedural safeguards, but that was back at a time when there were no rules in place. And the court made certain interim guidelines, all of which have been incorporated in Rule 419A. So the executive has gone way beyond PUCL in ensuring the constitutionality of the provision. The fact that they're not actually complying with it is whether or not they're actually complying with these procedural safeguards is a separate question, and that does not change the fact that PUCL is a settled law on this question. The second thing, my lords, is that under the necessity test, it is the petitioner's burden to provide us with certain less restrictive alternatives. The only alternative that the petitioners have provided us here is give them a prior hearing. My lords, as stated before, this alternative also has to meet the requirements of a surveillance regime in a real and substantial manner. In the case of Anuradha Bhasin versus Union of India, this court made two important notes of caution when it comes to the petitioners providing alternatives. It was A, this must meet it in a real and substantial manner. Merely giving us a less drastic alternative will not do the trick. Secondly, it must be in such a manner that that the wisdom of the legislature in enacting these statutes is not overridden. Now, my lords, as stated before, to meet the necessity test, any alternative would have to ensure within its fold secrecy as well as speed. When you give a person who is a subject of surveillance a prior hearing, both secrecy and speed are compromised. And therefore, the third prong is satisfied on that regard itself, and no alternative has been provided to us by the petitioner. And the way the test has been formulated, it is the burden of the petitioner to provide an equally effective but less restrictive alternative.
Thank you.
Lords, before we came into this dispute today, we believed that perhaps we might have a cause and not a case, but today we certainly believe that we have both. And to that effect, I'll make three quick submissions. The judgment referred to them, PUCL, says that there was no compelling reason and that it upheld the constitutionality of these provisions. But what also must be mentioned is that the PUCL court also clearly stated that there are no procedural safeguards, which is why it went down to lay that six-fold test, which we would also say is not something which enforcement agencies have been complying with. Apart from that, our remedy under Section 25 of the Telegraph Act is something which comes in at an ex post facto stage. What happens at a preliminary stage? Those procedural safeguards are something that the respondents have been silent on so far. Apart from that, the four-pronged stage that they mentioned, we would categorically like to contend that one cannot cherry pick in this case. While there might be legitimate state action, one must also ensure that the other three important prongs of these tests are met. And what we have contended time and time again throughout is that there were no preliminary procedural safeguards warranting interference of the state into the private lives of these individuals. An other observation which fell from my lords is that the orders in this case are not shown to the persons who are at the receiving end of it. My lords, it's commonplace, especially in our statutory provisions, for example, in the Coffee Posa Act, that the person, the detainee in that particular case, is served with a written copy of the order. My lords, they mentioned secrecy. We must say that there is a fine line of, may I just take 10 seconds to summarize? There's a fine line, there's a very big line of difference between secrecy and confidentiality. Confidentiality is something that can be maintained. Secrecy is the withholding of information, and certainly when my client is at the receiving end of it, there shouldn't be secrecy in this case. And lastly, my lord, we'd like to mention that they have not shown...
Any other judgment talked about confidentiality?
My lords, unfortunately...
Ratan Tata?
My lord, yes, apologies, my lords. With respect to that, my lords, the difference between the two is that confidentiality can be maintained, giving the other side an opportunity to respond to the allegations against them. But when we have an element of secrecy, we are basically not affording the other side to respond to the averments or allegations that are made against them. And lastly, to this effect, my lords, we would like to state that not every condition involving public safety as contemplated by the Law Commission, the 38th Law Commission, not every situation of public safety would escalate into a case of public emergency, which is why the specific provisions of the Telegraph Act use them separately. So we might have a case where public safety is in question, but not necessarily leading to an emergency. And specifically in this case, given the prevailing circumstances at the time, there was no proclamation made by the government that there was a public emergency in place, which is why we would humbly hope that this court rules these provisions to be unconstitutional. Thank you very much for your time.
Lordships, I'll be taking 2 minutes rebutting the first issue, and my co-counsel will be taking 2 minutes rebutting the second issue. Lordships, at the very beginning of my argument, I clarified our burden. Our burden was not to prove that both the issues, that is, whether the contract was determinable and whether the termination was valid. We just had to prove that one of them was not done for specific performance to happen. They had to prove that both were not done. Now, counsel for respondent came here and they conceded that the contract conceded on determinability. Now, if I may read out section 10 for the Lordship's clarity, section 10 states that the specific performance of a contract shall be enforced by the court subject to provisions contained in 11(2), 14 and 16. Now, since the contract is determinable in nature, the case doesn't stand. But in any case, counsel for respondents also said that we had kind of anticipated COVID. I had clarified this during my submissions. I said that we could not have possibly anticipated because the agreement was signed on 12th of January 2020. COVID started in February and the agreement was terminated in 30th of March 2020. With these, I rest my rebuttals.